things, as we should. We'll do another video and let the people.
Just waking up in the morning and knowing that nothing bad is going to happen to you necessarily. It's a very basic thing.
Yes. I love my grands, the children. They make me happy. And I love to see them happy too. Since I retired now, and I help out my daughters with my grands, because I think with a grandmother, a good grandma, you have the love for them, you watch out for them, and that keeps me going. The abuse started when they took the children from my daughter and put them in foster care. And then my daughter had like a resentment towards me. She'd be very like violent, you know, always want to fight. And she always was threatening to kill me. And this last time I was going downtown with my granddaughter and my grandson to do a petition for custody. And I don't know how she found out I was going that morning. But as we were leaving my apartment to go on the elevator, she was coming out. And she tried to pull my granddaughter, and I was holding her, and she started fighting me. I felt real bad, because it was my daughter, and she didn't have to go that route. You don't expect that from your family members. I would never in 100 years, if somebody would have told me in this lifetime that I would be facing this, I would say no. I cried at night, and so I wish it would go away.
We will continue. A couple join us at the front that I'd like to recognize. Associate Attorney General Tony West to my left here. Mr. West joined us at the event that we did in June at the White House, so I know of his commitment. So welcome. We're glad the Attorney General joined us this morning. Justice is well represented today, so we're very glad. And on the other end, David Spiegel with the Federal Trade Commission has also joined us. So we will continue with another very fine panel, and we will talk now on enhancing response. So let me introduce the panel. Laura Mosqueda, MD, is Director of Geriatrics at the University of California, Irvine School of Medicine. William Benson, that we all know as Bill, is the National Policy Advisor for the National Adult Protective Services Association. Laurie Stiegel is Senior Attorney with the American Bar Association, Commission on Law and Aging. Paige Ulrich is the Senior Deputy Prosecuting Attorney in King County, Washington. And Patricia Banks is Presiding Judge of Elder Law and Miscellaneous Remedies Division in Cook County, Illinois. And I believe, ma'am, you were with us also in June at the White House. So a fine panel. Welcome to you all. Dr. Mosqueda, we'll start with you.
Thank you. And remind me never to go to the movies with you.
What, you can't go to the movies with me?
Well, I don't know. You show really depressing
stuff. Oh, really bad films,
I thought I would just start with a brief story. And this was a couple of months ago. An Adult Protective Services social worker was notified that an elderly woman was living in a motel room with her adult daughter. We had an anonymous reporter who called because she was concerned that the older woman didn't look good. So the APS worker went for a visit. The daughter opened the door but wouldn't let her come into the motel room. But from the doorway, the APS worker could see an old woman sitting in a corner in kind of a darkened room, and there was a foul odor coming out. So she brought this concerning situation to our Orange County Elder Abuse Forensic Center in California for help on how to proceed. And let me just break by saying that this is a group of people, I think it's a fairly extraordinary team that comes together for 1 hour every Tuesday that includes representatives from Adult Protective Services, Ombudsman, Public Guardian, police, legal aid, district attorney, county mental health, a domestic violence expert, a geriatrician, a neuropsychologist. Those are the usual participants. And I'll mention that because I'm in an academic medical center, it also serves as a teaching site, and we have many students who come as well. So during this particular meeting, when the APS worker presented this case, the detective made a phone call and discovered right then that the daughter had been jailed several times for drug-related activity. So we made plans for a social worker, geriatrician, public guardian, and patrol officer to make a group visit the following day. This time when we went out, the daughter did not open the door. We knew that somebody was in there, so the officer was able to obtain a key from the clerk to perform a welfare check. We got into the room. It was cluttered with plastic bags. There was trash all over the place, clothes sort of strewn throughout. The elderly woman was sitting in a chair. She was very thin, filthy, confused. She smelled of feces. And on exam, she had an abnormal heart rhythm. She was dirty. She had very elongated nails. She was unable to get out of the chair by herself. We did a cognitive exam, and it wasn't just that she was confused. She really had a lot of memory problems and could not understand the situation that she was in. So as a result of our visit, an emergency guardianship was issued, and she was brought to a nursing home where she was cleaned and fed. The daughter was no longer able to access her mother's Social Security income. And we can come back and talk about that story if you want to, but to me it was an example of a multidisciplinary response that might be of interest. Separately, you can imagine that agencies face insurmountable obstacles in addressing abuse of elders. Collaborations among professionals with a variety of backgrounds are absolutely key for identification, intervention, and prevention. In fact, it's interesting to me that the need for interdisciplinary teams is so great that these teams form all over the country without funding, without mandates, without much help, to tell you the truth. Yet there are a growing number of communities that have multidisciplinary teams, financial abuse specialist teams, elder death review teams, and forensic centers or things like them. Why? Why is it so great to have an interdisciplinary team and so important? Well, for one, we provide swifter and more effective interventions. We improve access to needed services. Cases are more likely to be filed and prosecuted when appropriate. The combined wisdom and knowledge from a group of people from different perspectives really provides a forum for creative problem solving, which is often needed. And I think really an untapped resources for helping people like you identify gaps in services and policy issues. But even when all of the components are available for a team in any community, there are a lot of barriers to smooth and efficient implementation. Laws related to HIPAA and Ombudsman, for example, are interpreted in such a way that really hinders reporting and communication. Many cases that are really complicated either leave us with a choice of doing way too much or way too little. We rarely can find the just right sort of Goldilocks response that we're all in search of. We have limited understanding of each other's roles and responsibility. There's a lack of geriatric training among those in the criminal justice system and a lack of forensic training among those in medical and social service systems. And all of these issues impede the formation and function of interdisciplinary teams. There's also a dearth of easily available experts in one or more of the core team disciplines, and this leaves a hole in many communities' ability to respond. Fortunately, there are a lot of things that the federal government can do to help us overcome these and other barriers. Simply clarifying some of the existing federal rules and regulations, such as what I mentioned related to HIPAA and the Ombudsman, the Ombudsman's authority to report abuse, can enhance interdisciplinary communication. That requires no funding, simply clarification that goes out across the country. You can create guidelines to promote sharing of information across agencies. You can make it easier for us to use technology and to help each other across state lines. You can insist that interdisciplinary responses be integrated into existing programs that serve older adults. Paul Greenwood, my colleague who's a prosecutor in San Diego, mentioned rapid response teams, which is also something I've noted. We do this in medicine in hospitals. Instead of waiting for somebody to code now, many hospitals have rapid response teams that see when somebody's in trouble, and you get the right group of people to them quickly before there's a code. We should be applying the same kind of principles to elder abuse. You need to support research in the areas of standardized measurement, data collection, evaluation, and translation, and then promote the use of evidence-based best practice models. We have to have national leadership on this issue. And just as we found, I think, individually at the local level, that we've had to move from a silo mentality to the village mentality, we think the same applies at the federal level as well. Communication, cooperation, shared goals among the agencies represented here can really promote understanding and efficiency and coordinated action. However you accomplish this, be it by creating a new position in the government so that we know where the buck stops, or by some other mechanism, the need for national leadership is urgent and clear. Too many of our nation's elders are becoming impoverished, are suffering, and are dying as a result of abuse. Somebody said earlier that the problem is that people fall through the cracks. And I think the problem is that we not only have cracks, we have huge crevasses in our systems. And it's not that people are falling through it, it's that we have these cracks and these crevasses, and that's what we really need to fix. Thank you.
Thank you very much. Bill.
It's an honor to speak to you today on behalf of the National Adult Protective Services Association, or NAPSA. NAPSA represents the nation's state and local adult protective services programs. Your convening today represents a significant step toward implementing the landmark Elder Justice Act and a federal commitment to addressing elder abuse, neglect, and exploitation. APS is the nation's state-based, statutorily authorized system for investigating elder abuse, neglect, and exploitation, and responding to and protecting its victims as best possible. APS, which in most states also responds to abused younger adults with significant disabilities, operates under state laws in every community. APS is the primary system we have for responding to vulnerable older adults who are victims of elder abuse. I note with some pride about APS that I think 6 of the 8 preceding speakers have all mentioned APS. Not that I'm keeping track. Research shows us that there are more elder abuse victims than other types of abuse victims, such as victims of child abuse and domestic violence. Yet older victims are the only ones who receive no designated federal support for services. Federal support and attention to other types of abuse have resulted in reduced incidences of both child abuse and domestic violence homicides. APS relies heavily on state and local funds, which have been under intense pressure over the last few years. APS receives no designated federal funding, although 60% of states opt to use some social services block grant funds to support APS. The Elder Justice Act authorizes the first ever dedicated funding for APS, but thus far, as we all know, not a dollar has been appropriated. Every single day, state and local APS investigators, caseworkers, and others in every state do the best they can to deal with an onslaught of increasingly difficult, complex cases. They do so with virtually no national infrastructure behind them. As the GAO noted in the report last year, there is no federal agency with responsibility for APS, although we're very thrilled that Assistant Secretary Greenlee would like to be that place. There's no national data system, nor practice standards, nor minimal training standards, nor a host of other things that would constitute support for this program on a national basis. In our written testimony, we offer a number of suggestions as to what the federal response could be to strengthen and support APS to better address the needs of victims. The white paper we are preparing will elaborate on each of those points, but in the limited time I have, I want to briefly touch upon several of our suggestions. First, there is a great need for support for research about the effectiveness of APS interventions, promising practices, and optimal outcomes for victims. We need to develop and field test field-friendly capacity assessment and screening tools to replace antiquated tools that are currently being used by APS, such as the mini mental status exam still used by APS in 22 states. The field needs new, easy-to-use tools that are not costly in terms of either time or money. As the GAO called for and others have said, it is imperative that a national data system be developed, tested, and implemented that will be capable of annually telling us how many cases are reported to APS, what types of abuse those cases allege, how many are substantiated after investigation, and other important data about elder and vulnerable adult abuse. Federal victim services funds, such as VOCA and VAWA, should be allocated to older victims in proportion to their numbers and needs. Older victims of abuse are underrepresented by these other victim services programs, both in terms of the dollars allocated and in the services provided. We believe that the aging and disability services networks need to be better educated about recognizing, reporting, and responding to elder abuse, as well as other forms of non-elder adult abuse. With 47 states having mandatory reporting laws, these networks, along with many others, including federal employees, need to be trained about their responsibilities and about elder abuse in general. It is important to expand training for law enforcement, prosecutors, and judges to all forms of elder and vulnerable adult abuse, and to make that training widely and easily available throughout the country. While not all elder abuse is criminal in nature, the abuse that is needs to be thoroughly investigated and prosecuted. We need to move from training hundreds in law enforcement and prosecution to thousands. We wholeheartedly applaud Assistant Secretary Greenlee for her leadership in funding the first ever National APS Resource Center. It is an important step toward building a modest national infrastructure to support and strengthen adult protective services. This center needs to be an ongoing part of the federal response to elder abuse. I might also take the opportunity to applaud her for funding the first ever resource center dedicated to addressing elder abuse in Indian country. Terribly neglected area, and it's an area in which we need to do more work to collaborate between states and state APS systems, law enforcement, and tribal officials. And finally, we remain thrilled by the enactment of the Elder Justice Act as part of the Affordable Care Act. But the great promise of this new law, especially the authorized support for desperately needed funds for states, is an unfulfilled promise until we have some funding that comes through for that piece of legislation. A stable source of funding to states and local communities for adult protective services will save victims' lives, it will improve investigations and investigative outcomes, and it will save us money in other programs such as Medicaid. Thank you again for this opportunity to offer NAPSA's thoughts today.
Thank you very much. Lori Stiegel, ABA.
Thank you for inviting me to be here today and for convening this. And I need to give the caveat that I'm talking twice as long as everybody else because I'm talking about
With permission,
civil
we have
le-
requested
yes,
that you
I'm
talk
talking about
two
civil
things.
legal services and about the courts as well. So, and I also, like my colleague Erica, being a lawyer, need to give a disclaimer that I'm not speaking on behalf of the American Bar Association today, although what I'll be talking about largely stems from my work there. Also, like Assistant Secretary Greenlee, I'm a once and always legal services lawyer. And those programs are central to my testimony because so many of the victims who we've talked about and heard about today can't afford to pay for a private lawyer. But there is a role for private lawyers to play in preventing, detecting, and redressing abuse. And we also know that civil lawyers play many other roles as well. Many of us here in the room are civil lawyers working on elder abuse issues. We advise protective services, or we work for the State Attorney General's office, or for our other governmental agencies. Civil lawyers who may be working for financial services industries are increasingly playing a role in dealing with the problem of elder abuse. And of course, we help create laws, whether as legislators or as staff to legislators and policymakers. I'm going to highlight 4 gaps and then talk about 3 ways that I think the federal government can help start to fill those gaps. First, we know that many victims are challenged in their ability to obtain civil legal services. They don't recognize what's happening to them in the first place, thus the need for public awareness, but they don't see how civil legal services can help. We've done a lot of improvement on dealing with the criminal justice aspects of the problem, and we need to start doing the same on civil legal services. They need help in finding those services. Those of us who deal with this every day know what's out there, but the public still doesn't. I'm constantly astounded when I get calls from people who've worked their way all the way up to me but have not found their local legal services provider to help them in their community. Services need to be affordable, they need to be accessible to them, and whether that's through an Older Americans Act funded program, through the Legal Services Corporation, through pro bono, through a private lawyer, that needs to happen. But it's not enough just to have a lawyer. You have to have a lawyer who knows about elder abuse, who understands the problem, can help you work to prevent it, can detect it if it's already happening to you, and knows what remedies to pursue and how to do it. They need to understand diminished capacity. So that's just as relevant as it is to the other professionals we've talked about today. They need to understand undue influence. We're increasingly seeing how critical that is. No matter what role civil lawyers play, they need training, but preferably starting in law school, if not then or in addition to then, occurring after they've passed the bar through continuing legal education programs and so forth. But they also need much more than that. I constantly get requests for case analyses, for brief banks, for information on what expert witness to find and how to find them and assess whether they would be appropriate or not. They're looking for legislative analyses, case consultations, the kind of things that we've seen the federal government support for child abuse and for domestic violence need to happen in elder abuse as well. The Missing Link project that the Department of Justice is talking about implementing at the White House event, and I know that they're working on it, is a drop in the bucket. It'll be a great start, but it's only one piece, and we hope it will develop further in the future. I want to talk some about what civil lawyers can bring to the table, though, to help protective services and other agencies and the federal government as well. Understanding the role that civil lawyers can bring, if you're an APS professional, law enforcement, healthcare, any others, can also help victims directly, because then you're better able to make a timely, appropriate referral to a civil legal services provider. But they also should be at the table in the multidisciplinary initiatives that we've been talking about today that can bring a wealth of knowledge to efforts to build systems, change laws, and serve victims. And federal legislators and policymakers, as well as state legislators and policymakers, also need to hear from civil lawyers about the impact of laws, about what laws are out there, whether there are barriers to reporting, to sharing information, all the issues that we've heard about today. That's the brain power that civil lawyers can bring to the table. So let me talk quickly about some ways that I think the federal government can deal with these gaps. One of my favorite lines from the West Wing was when President Bartlett said that he was a human starter gun. And in the context he was talking about, that was a negative thing, but I think in general it's a positive thing. And I think that all of you here can use your power as human starter guns in your agencies and broader in the community and nationally to raise these issues to a higher level of attention. And I don't mean to pick on DOJ, but I've been to a lot of DOJ conferences over the years where, unless it's specifically focused on elder abuse, you never hear those words in the plenary sessions or from the higher level officials. They talk a lot about child abuse, they talk a lot about domestic violence and other important issues, but I'd like to see elder abuse start working its way in there too. You certainly can use your existing resources to try and fold these efforts in. MT spoke a lot about that. And again, bringing civil lawyers into the mix, bringing civil lawyers, bringing elder abuse into the issues that you're already working to train civil lawyers about will be a huge boon. In the more medium term, I think that once you start that human starter gun effect, to really and fold these into your existing programs, even without the additional resources that we all know are needed, can be a real benefit. The Office for Victims of Crime, through its Wraparound Legal Services program, is working to benefit all victims of crime and to make sure that they get the civil legal services that they need, as well as the criminal justice process and victim services that they need. But we need to be sure that elder abuse is included in that effort as well. I think that there are things that the Administration on Aging can do in trying to push state units on aging and area agencies on aging to provide more funding to civil legal services and to really emphasize to them the need to deal with elder abuse. I know that's a pet issue of yours. Civil legal services can also provide us with information that will help us assess the costs of elder abuse and the impact of elder abuse on the Medicaid budget, and even potentially on the criminal justice budget. When I worked for legal services, we, even though we were not required to do this, kept very detailed records of what financial benefit we brought to our clients. And when we informed our area agency on that, at times when they were cutting other services, they would increase our budget because we were able to demonstrate the value that we were bringing. So we know that that information can be kept. They're generally not doing it voluntarily, as my old program did. And so whether we use a carrot or a stick, maybe we need to help that, because that's the sort of data we all need, and they can provide some really useful data. I talked already, and other folks have talked about the need to review laws, policies, and programs to see if coordination is hindered or helped by our current system of laws. In the longer term, I know that funding and new resources and money are bad words these days, but we all know that that's what's needed in the longer term. And certainly, again, using your bully pulpit to try and get that. In the previous administration, we saw examples of them actively opposing efforts to try and get those resources. So we hope that those kinds of things will not continue. It's very delightful and great to see the newer research that's coming out on decision-making capacity, and certainly continuing to support that and translating it to make it useful to civil lawyers as well as the other professionals we're talking about will be critical. Now I'll move on to the court system. I have worked for 19 years at the ABA on elder abuse, and it's interesting that my first work on elder abuse in the early 90s and now my more recent work with an NIJ project that just wrapped up last year have been about courts. And the sad thing is that the recommendations that we developed in the mid-90s when we did a big research project funded by the State Justice Institute on whether elder abuse cases that were going into the court system, if not, why not, what could we do about it? Those recommendations, those issues are just as timely today as they were 19 years ago. And that's a sad fact because it shows how little progress there has been in involving the courts and recognizing the role of the courts in this problem. I again will highlight 4 major gaps and then sort of do the same thing I did with short, medium, long-term issues. And my work has really been focused on state courts, but I think much of what I say will apply to federal courts as well. Courts have provided leadership and community education to the public and in their communities on child abuse, on domestic violence. A few of them are doing that on elder abuse. An example will be what Judge Banks will talk about in the new Chicago court. But we really have not seen much of that. And the federal government supporting that, making it a priority, pushing the courts to do that, would really have a boon, because when courts talk, when judges want something to happen, it happens, just in the same way that when you ask us to come to these things, we do it. We all know that's how it works. Having the courts include civil lawyers on court advisory councils or whatever they may call them is also really important in a way of enhancing the bar's response then to the problem. Judges can, within the confines of their ethical responsibilities, do public awareness. They can speak at bar association meetings or CLE programs on these issues, and those things could make a huge difference. Judges and court staff need training on the myriad issues related to elder abuse. I won't go into all the details about what those are. I'll do that in my written paper. There's a recent curriculum developed. We had developed a curriculum in the 90s with State Justice Institute money. The National Center for State Courts has recently updated that and is putting it online using money from the Bureau of Justice Assistance and a foundation. That's great, but we've really got to get the word out and make sure judges are participating and getting that training. Judges don't recognize that they're seeing elder abuse cases. They don't come in labeled as elder abuse. They're guardianship cases. They're murder cases. They may come in under all kinds of guises, and judges, like all the rest of us, are so busy that they're not going to take the time to learn about something that they don't recognize that they're seeing come before them. So we have to get the messages out to them that they are seeing them, and it's not just a guardianship judge or an elder judge who's seeing them. All sorts of judges are. Courts need to learn about and consider implementing different ways of meeting the needs of older litigants who appear before them. We recently looked at 5 different communities across the country that were setting up sort of 3 categories of what we generically labeled as court-focused elder abuse initiatives. 2 were elder protection courts, similar to what Judge Banks will talk about. 2 were elder justice centers, and then there was, 1 was an elder protection court, 2 elder justice centers, and 2 programs that helped homebound litigants get protection orders by telephone from the court. These things and other sorts of progressive, innovative court processes are really necessary to meet the needs of older litigants who are terrified of going to court, who can't sit on hard benches all day long, particularly without breaks, without lunch, or the ability to take their medicines, who can't get up the stairs in older courthouses. These are real issues that inhibit their pursuit of justice. We need further assessment of the role of the courts, and particularly of these new initiatives like Judge Banks, like the ones that we just studied. But that raises some really complicated issues about data collection. And we found in doing our assessment that when we would ask the courts and the court-related programs what they were doing to collect data, to evaluate data themselves, they would get a blank look in their eyes and say to us, "That's your role, that's why we're playing with you." So one of the issues we looked at was, well, what data are they collecting, and is there going to be something that could support a more in-depth evaluation than what we were doing at the time? We were really assessing them, not evaluating them. And not to our surprise, but to our continued horror, that data is just not there. Part of the reason is that courts don't see their role as evaluating themselves. And part of that role, I think, is now shifting because courts have been facing huge budget cuts and have a greater understanding that they need to evidence to state legislators that if you cut our funds, this is the impact on the broader society, the broader economy. So the mindset may be a little bit ripe for what I'm talking about. But they also just don't collect data. One thing we heard often was that, well, if we, and it's similar to the bank issue we heard earlier, that if we write down their age, we're committing age discrimination. Well, of course they're not, but apparently we have to get that message across to them. The problem, again, of court cases not being labeled as elder abuse cases means the data's not there. And it's sort of interesting that for many years, the policy wonks among the elder abuse field have been talking about, well, you don't need, when you're talking to a prosecutor or to law enforcement, you tell them you don't have to have an elder abuse law in order to bring a case. You can use your murder and rape laws and other laws. And that's true, and you want to encourage prosecutors not to say, oh, I can't take that case, we don't have an elder abuse law. But of course it means the data's not there, and we need to find ways to support the courts in collecting and developing this data, because otherwise we can't do everything else that needs to stem from that data.
Lori, we're going to have some questions for you, but I
Okay.
want to make sure we can get the judge in, because I've asked Paige to talk about a couple of things, too.
Okay, excellent.
So, is there, I don't want to
my
miss
three
a
things
sort
are
of a
just
closing
basically,
point that you might have.
again, that bully pulpit, short, medium term of working this into your existing work in your agencies, and then the longer term of funding and resources.
I think your role in the middle of the panel is a nice and interesting transition to the courts. And what I leaned over to say to Mr. West is I've always thought about DOJ as helping us on the prosecution side, but this light bulb is like, you can help us with the courts. So I'm looking
And the
forward to kind of
civil side,
exploring
too.
Yeah. So let me go to Paige before we have the judge close this. So.
Thank you. Thank you all to all of you at the Elder Justice Coordinating Council for asking me to speak today. It's a true honor to be here. I'm going to be speaking about issues faced by law enforcement and prosecutors in responding to elder abuse cases at a local level. And I'll be talking about both those subjects together, since I think they're very intertwined. I've prosecuted felony-level elder abuse cases for over 10 years at the King County Prosecutor's Office in Seattle. My office is unusually well-resourced compared to other prosecutors' offices around the country when it comes to elder abuse. We have 2 dedicated elder abuse prosecutors. We have a financial analyst who analyzes the extensive financial documents that are so often a part of these cases. One of the largest of the police agencies that we work with has several specialized elder abuse detectives, as well as an elder abuse victim advocate, which is a rarity in our state. We are also lucky enough to have been a recipient of the Office on Violence Against Women's Elder Abuse Training Grant, which has allowed us to train law enforcement, prosecutors, judges, and direct service providers on elder abuse recognition and response. And we are also the lucky recipients of a grant from the Bureau of Justice Statistics to gather data on the cases we are prosecuting and the outcome of those cases, and looking at the many different factors that go into our filing charges, and then the results that we end up getting on those cases. On a table in our elder abuse unit sits a stack of documents almost 2 feet high. This stack consists of copies of reports of elder abuse recently faxed by Adult Protective Services to the 39 police agencies in our county. Each document contains a summary of a phone call made to APS's hotline by someone reporting a case of possible physical or sexual assault, neglect, financial exploitation, or homicide of an elder or vulnerable adult. It is by these faxes that APS makes their reports to law enforcement in our jurisdiction. Years ago, my office asked APS to send us copies of these faxes so we could occasionally follow up with law enforcement on some of the more serious cases out of concern that law enforcement might mistake them for being civil matters rather than potentially crimes, and also to encourage them to coordinate their investigations with those of Adult Protective Services. We had reason to be concerned about that. Investigating and prosecuting these cases is extremely difficult. It requires knowledge of concepts like capacity, dementia, consent, guardianships, wills, powers of attorney, and forensics of elder abuse, subjects that law enforcement rarely receives training on and that prosecutors haven't dealt with in law school, if at all. These cases almost always require the assistance of financial, medical, and/or capacity experts as well. In Washington State, as in most states, APS is a primary clearinghouse for reports of elder abuse. Yet APS in our state does not have sufficient funding to staff a 24-hour hotline, so law enforcement often receives these faxes days later after they have occurred and after they've been reported. Each of the 39 police agencies in King County that receives these APS reports handles them differently. The one agency that has specialized elder abuse detectives reviews each report, calls APS to follow up if they need to, and assigns anything that appears to be criminal to its elder abuse detectives for investigation. Not coincidentally, it is from this one police agency that our elder abuse unit gets the vast majority of its cases. Further, it is those specialized detectives who are the most actively involved in our county's elder abuse multidisciplinary team, elder fatality review team, and in doing trainings for the community, and who have the strongest connections with local experts who assist them in developing the evidence they need to build their cases. Again, not coincidentally, this is the one agency with whom we do not need to follow up to make sure they are responding to those APS faxes. As for the other 38 agencies without specialized detectives, how they respond to one of those reports differs widely, depending on whether they have received our OVW training, whether they place a significant priority on elder abuse cases or not. From some of these agencies, we do receive cases, and from others, we don't. Despite our relative abundance of resources in King County, the pile of reports in our office continues to grow. As we have conducted more trainings for law enforcement through our grant, and as our visibility has increased, our elder abuse caseload has risen dramatically. Now we are lucky when we can triage the most serious of those APS reports to make sure they're followed up on. Despite our best efforts, we are failing countless older victims of criminal neglect, abuse, and exploitation every day in our county. In most other jurisdictions in this country, the situation is far worse than in King County. Most do not have specialized elder abuse prosecutors or detectives. They have received no training on elder abuse. They have no multidisciplinary teams or connections with experts or anyone to whom they can turn for help. Elder abuse cases are being handled across the country by local prosecutors' offices with local law enforcement, local medical examiners, and state APS, ombudsmen, and departments of health and welfare. But this is an issue that is bigger than any of us. We urgently need information and support that only federal involvement can provide us. In that vein, I have 3 recommendations for federal agencies that are part of this council that I think would make a huge difference to those of us on the front lines of law enforcement and prosecution. One is to fund, pilot test, and collect data on the impact of specialized elder abuse detectives, prosecutors, and victim advocates in a few jurisdictions. The second is to create and fund a national resource center for the investigation and prosecution of elder abuse, to accompany the website that DOJ is already developing, to provide technical assistance and support to law enforcement and prosecutors on these cases, and to disseminate some of this vitally important information that we've been talking about throughout the day today. The third is to conduct and expand our research and data collection, like our current project with BJS, to ensure that we have the knowledge base we need to support our cases and to help us answer the many questions we have about what cases are and are not coming into the criminal justice system and why, and what is happening to these cases when they do come in and why, and the impact of a multidisciplinary response on these cases and on our victims. The more cases of elder abuse I handle, the more aware I become of the extent to which failures in our many systems contribute to its occurrence. It is only through collaboration among these systems at all levels of government and with the development, support, and coordination of federal programs and initiatives that we will ever see real progress in our battle against elder abuse. We are in desperate need of your help. Thank you.
Thank you very much. Judge Banks.
Thank you. Good afternoon, everyone. This is the Circuit Court of Cook County, of course, is very grateful that the judiciary was included in this dialogue having to do with the aging issues and what type of judicial response the courts need and should make with reference to elder abuse, neglect, and financial exploitation. Today, we welcome the opportunity to share with the Elder Justice Coordinating Council the road taken by the Circuit Court of Cook County in developing our Elder Law and Miscellaneous Remedies Division. Now, this is a mouthful, so it's Elmer for purposes
Elmer?
of...
Okay.
Yes, Elmer. Okay.
He's not just some dude. He's your
This
okay.
is Elmer, okay. Cook County is one of the largest unified court systems in the world, and so it was with some trepidation that Chief Judge Evans, made the bold decision in 2010, December, to create a new court division. We have 16 divisions in our court system, handling cases from the criminal cases to the chancery matters. Judge Evans felt that we needed an elder law court because the elderly litigants was utilized in every division in our court in order to get some type of remedy or some type of redress for matters. Well, this created a problem for us because we weren't addressing the issues. These 400 judges that we have in our system was not addressing issues of abuse, neglect, and financial exploitation in a holistic and focused manner. Allowing these cases to be filed throughout the system, as Larry mentioned, did not allow us to keep good records. There was no collection of data. We couldn't track the cases, and we didn't really offer the best, disposition of these cases. There were deficiencies, of course, because of the fact that there was no specialized court. We, in turn, did not provide for physical access for the elderly. We did not provide audio and visual aids for the elderly. The judiciary and the court personnel not trained appropriately. What happens when this happens? Well, number one, this is a generic treatment of incidences of elder abuse, neglect, and financial exploitation. There was more recidivism. There were some instances of, I would say, unwarranted guardianships, because the way you keep people from being exploited is to place them in a guardianship position. And that's the end of that, but that's not the answer. There were also perhaps involuntary mental health commitments and substantial loss of property. Chief Judge Evans committed resources. Although we have very limited resources based on all the budgetary restraints in this era, he did commit the resources such as 2 full staff members to work with me, along with myself being taken off of other cases to work exclusively on developing an elder court as well as Elder Justice Resource Center. I'd like to tell you just a little bit about the process, and I know that I will elaborate on these issues in my white paper in, of course, greater detail. The first thing that we did was to begin with the formation of a work group, 16 very, very, I would say, focused groups, individuals, to work within the work group. We selected the work group based on their knowledge of the issues, the resources available to these groups, their connections with the senior community, and commitment to the goal of establishing or creating an elder protection court This included the city and county area agency on aging, the public defender, the sheriff's department, well, law enforcement, you might say, the sheriff and the Chicago Police Department, the attorney general, elder law practitioners, the public guardian, law schools with elder law programs. We formed committees, and these committees were broken down to subcommittees where we discuss issues such as the threshold age for the elder law court, the types of cases that might be appropriate for handling in the elder law court. We looked at models. I was allowed to travel around the country to basically look at models that were already in existence on a very, I would say, a smaller level than what we were contemplating or eventually ended up modeling. I visited California. I visited Florida, and actually had an opportunity to observe Elder Justice Center as well as several elder protection courts that were, I would say, in operation on a once-a-week basis. Now, the end result of what we've done is as follows. We have created an elder protection court, which we hope to be a model. What we have created is as follows. We have judges that have been assigned and trained to handle elder abuse and neglect cases in the criminal division exclusively. Judge Evans has assigned 3 judges to handle only elder abuse, neglect, and financial exploitation cases. We are going to, we've also have a person or persons who are victims assistants to help these victims along. It's a victim-based process as opposed to trying to deal with elderly people who are defendants as well as plaintiffs. In addition to that, we have looked into the domestic violence division of our courts, and we have identified 2 judges to handle cases involving seniors over the age of 60. These cases heretofore were being handled in such a fashion that the intake people were eyeballing individuals coming into the courthouse, determining that this person might require the assistance of a victim's advocate, and the other elderly individuals were then sent into the pool, say with 10 or 12 judges to handle his or her matter. Now, what we are doing is we have 2 judges assigned exclusively to handle cases of domestic abuse involving the elderly. We have a victim's advocate who will no longer have to run around our domestic violence division trying to catch up with these various litigants. And there will be a different, holistic approach. This victim's advocate will be able to link the victim with services and be able to, in fact, approach it in a more holistic fashion. In the civil court, we have 200 judges in our daily center. The civil judges that have been assigned to this division will handle matters involving, civil matters, and that runs the gamut. These cases will involve cases having to do with financial exploitation, cases that might arise under our Elder Abuse and Neglect Act, cases having to do with abuses of power of attorneys. Now, I'm fast-forwarding here because I know that time is limited, but the thought is that by having all the judges of the Circuit Court of Cook County who have already, over the last year and a half, received some training and are already, we have prepared a bench card for judges throughout our system to view while these judges are on the bench in order to maybe red flag, identify some of these cases that would be more appropriate in the elder law division. These cases will be assigned to my division, and my judges will then address these issues. These litigants will be assisted further by utilizing services of the Elder Justice Center. I have a number of task force members who we do have a task force. That task force has agreed and is actually assisting the court with reference to legal services, and the task force is 45 strong, and we have various disciplines. Medical personnel, medical professionals are part of this task force, as well as law enforcement, on and on and on. A number of my task force members are here.
Good.
But thank you so much. I do want to say just two more remarks I'd like to make. Challenges, it's attempting to convince lawyers within our system, and we have training programs in order to help that along, and convincing others that this is a necessary piece, that we really need to have an elder court. The other challenge is collecting the data, as already has been stated. Another challenge we have is creating methods to collect age data, and overall just raising the awareness and sensitizing judges and court personnel to aging issues so that we are able to address issues of elder litigants in a better fashion. These courts are essential to the present and future well-being of the elderly. We need resource centers. We need training for judges and support staff, facilities, and equipment. We need to provide transportation to facilitate court appearances. We need audio-visual equipment in the courtrooms. And we need lots and lots of training for all of our, for everyone involved with the court process. Thank you very much for your time. I apologize for going over.
No, thank you. Thank you very much. Thank you. Let's thank the panel. I alerted Attorney General West I was going to ask him, give him the mic first if he has questions, and then Mr. Spiegel, you're new to the panel. I'll come to you second, just because I want to make sure that everybody has a chance to speak today. So,
well, thank you, Kathy. I appreciate it. Thank all of the panelists for excellent presentations. This is an issue that I've had the privilege to work on for a while in my various time, not only here at the Department of Justice, but at the California Attorney General's office years ago. And you know, I think there's a lot that has been done in the many years that we've all been working on this, but it's so clear that much more work needs to be done. We have a long way to go. I actually have questions for everybody, but why don't I just start with Bill? You know, one of the things you were talking about was the need for better tools in the field, and particularly the use of sort of outdated tools in the field. And I was wondering if you could talk a little bit more about what some of those new cost-effective tools that you've encountered are, and whether or not there are any pilot programs going on, whether or not there's any funding that's going on in particular areas around the country that are bolstering the use of certain tools that have been identified as particularly effective, particularly user-friendly.
I think my answer will probably be very brief because I really can't tell you about many tools that are being pilot tested. We know that so many of the individuals that APS are seeing, as anybody who works in elder abuse, are people with cognitive impairments, whether they're mild cognitive impairments or extreme cognitive impairments. We know we need tools to help APS frontline workers be able to make some assessments about cognitive capacity. And we've relied on some really outdated tools that I think people like Laura can speak to from the previous panel, or excuse me, Laura here, better than I can about the mini mental status test. They just don't work very well. They're not appropriate, and we don't have to replace them. So I think that one of the issues that's needed are the development of these tools, the testing of them, the validation of them, and then to start using them in the field. I think we need to do, in terms of tools, there's no question there's need for use of better technology. The NAPSA, through the National APS Resource Center in collaboration with the National Association of States United for Disabilities that represents the state units on aging, did a survey of all state units on aging about a variety of issues related to APS, just released this report in the last few weeks, and reported on the number of programs that are using things like laptops or even cell phones. I think we are really behind the curve in terms of using even the technologies that are available to help people in the field that are out investigating cases. I did a study of an area agency on aging APS program a few years ago, and APS workers did not even have cell phones that were issued to them as they went into some unbelievably tough neighborhoods to investigate complaints. And their working issues were things like my car breaks down in a really nasty neighborhood, and I don't even have a cell phone, much less a computer to help me out with these cases. So I think we've got a whole lot of work to do in developing new tools, whether they're technology that's available, or instruments, or assessment devices. We've got a long ways to go.
Thank you.
Can I interject that the ABA has developed a series of guides on capacity assessment for lawyers, for judges, and we've done that in conjunction with the American Psychological Association, so they have more on their own, developed one for psychologists. We have been trying for years to get someone to fund us to do one for Adult Protective Services and haven't been able to get the funding. That would be a huge boon to meet that need.
Absolutely. The other thing that each of you have mentioned, data collection and the lack of good data out there. And I guess the other question I had was, where do we see the greatest deficiency in the type of data? I mean, there's data that I know OJP, for instance, has funded some data collection to raise awareness and to raise the ability to identify elder abuse, but there's also data needed on the court system. There's data needed in the types of prosecutions that we're bringing and how effective we are in some of the things that we are actually doing, data to measure our effectiveness. I mean, is there any sense of where our greatest deficiency in data is when you start to break that question down as it relates to elder abuse?
Judge, yeah.
Talked too long already. However, I'm thinking that what we need is data basically to find out where, why is the court putting together a program such as this? Will the elderly be better off? We don't know. Should they continue to do what they're doing already, going from court to court, playing, I would say, poker with their respective cases? We need to have concrete data in terms of the number of cases that we'll be receiving, and then we'd like to know, was this case disposed of quicker? Was there a better result as a result of what we're doing by zeroing in on this particular problem and taking care of the entire problem? Not just the fact that this person is being evicted from his or her home, but we also want to know if we approach it in the fashion that Cook County is planning on approaching this. Did we also find out about whether there is financial exploitation going on, and did we resolve that issue? And what other issues are there? There might be some medical issues. There might be some bad medication. It's a lot of, but we don't have time based on, and that's the problem. We want to do all these things, but on the one hand, we're trying to administer justice. At the same time, we need people from outside, help from all the agencies and departments to come in and help us get this data. I'm sure you know people have those resources.
Bill, do you have a rank order for?
Well, I would say,
is all of the above a choice?
I think all of the above is probably
when I listen to Paige talk about the stack of faxes with complaint data from APS coming into their office, and they do something with that. Hopefully, and I don't know this, in Washington State, at least at the state level, they aggregate the APS complaints into a state common system. Most states have some common system, but they do not talk to each other across the country. So we don't have any way to aggregate what Paige is getting at the local level, which is really important, telling us what kinds of abuse is going on out there, against whom, what do we know about the perpetrators, what do we know about the victims. We are unable to aggregate that data. That alone, just APS data, if it were aggregated nationally, would give us a heck of a view of what's going on out there. We don't know it.
And can I add one thing to your question? I think the answer really depends on what discipline the respondent to your question is in, and the struggles they're personally dealing with in their attempts to deal with elder abuse. But it seems like the one area that is common to all of our disciplines is that of capacity and dementia. And that cuts across all of these disciplines and really affects us deeply in all of the work that we're trying to do. And it seems to me, from my perspective anyway, that that's a very important area for us to start addressing.
Laura, you wanted to jump in because...
Right. Just one comment.
Speaking of capacity. The doctor can weigh in.
and
here.
lack thereof. One comment about data, I mean, it always sounds great to collect data, and it makes us feel good to have numbers, and you can put them together and make really great-looking charts and graphs and all that kind of stuff, and it's nice. But there's a real garbage in, garbage out phenomenon that we have done really well in our field of elder abuse, where we have collected data and put it together and came out with these sorts of, and I'm very concerned about aggregating data even at the state level. And what we have found and are working on publishing right now is just looking at across the state of California, the incredible variability of what's getting reported that simply cannot be explained by true variability at each community level. It can only be explained by the fact that everybody views it differently. And so I think we have got to be very careful when we start saying we're just going to collect all this stuff and put it all together, and realize that a lot of the stuff that we're aggregating just simply isn't valid. And so I just would urge a little bit of caution.
Just one other point. I'm working with a couple of graduate schools of social work in terms of helping me to identify what it is I need to collect. I think that is important. You're right, garbage in, garbage out. And when we first started with developing the Cook County Circuit Court's elder law model, we actually had conversations with Lori Stiegel. We had a conference call, and during the course of that conference call, she and Erica emphasized to me the need to collect good data, and I've kept that in mind.
So can I jump in? Our audience would like a break here, I can sense. So I was wondering if we could do about 5 more minutes, if that's okay. We've got one more panel after this, but Mr. West, I want you to.
Well,
We're glad you're here, so I want to make sure.
no, I just, I only have one more question. I don't want to monopolize the time. On the Cook County model, I'm curious about the coordination with law enforcement while you were putting together that model, and whether or not the way that you now process elder abuse cases has impacted the way law enforcement investigates elder abuse cases, collects them, recognizes them, organizes them, prosecutes them.
It's too soon to tell because we're very brand new at this. However, I will say that from the very beginning, the circuit court involved the Chicago Police Department. The person on my part of my work group is a representative who's over senior services for the Chicago Police Department. I also reached out to the county sheriff, and I have other law enforcement people, and APS, and so that, and the state's attorney. And so we are all working together, and we believe that it will make a difference because of the fact that we're on one page.
And, may I just say anecdotally, when I look at what people like Paige Ulrey and Paul Greenwood have done, it's absolutely clear in their communities when they have police who know that they have folks in the district attorney's office who are interested, that the police are much more willing to put in the time and effort required to give them the information they need to make a decision about prosecuting a case. That's absolutely clear.
And in the courts where we studied, having the court interested also has that effect.
Exactly.
I was wondering if I could just grab the mic and jump in with. If I'm going to sort of. It strikes me that we're well represented from large cities, with Los Angeles, Seattle, and Chicago being here, and all of you talked about a collaborative effort, where it's a forensic center or judge, what you're talking about. Do you have any advice for rural America? I mean, we will not have the resources or even the talent, and I have visited a center. Man, what do we do about small towns that you all are facing gaps in huge cities? What do we do about the rest of the country and isolated America?
Well, I think this is a place where technology can play a major role. We've applied for a grant, and unfortunately there aren't a lot of federal grants for these sorts of things, but we've applied to a foundation to see if we can look at the use of FaceTime and in a community that's more rural than where we are, and give them equipment to then beam back to our forensic center when needed. The difficulty is people need help right then usually. It's usually an urgent situation, and they can't wait around for the monthly MDT meeting. And that's why I think technology can be very helpful. We just need to prove that you're able to do the kinds of exams you need using technology to a reasonable extent that it ends up being helpful, but so that rural communities are not feeling like they've just been left in the lurch without all the personnel that they might need.
Anybody else on rural? I just want to broaden our questions. Yeah.
Just that even though we are in a city, we had no funding for any kind of multidisciplinary effort in our county, and we started it just by convening everyone we could think of who might be interested and brought them together over the lunch hour and sat them down and said, what is the one thing that prevents you from doing a good job at your work with regard to older victims? And from that group meeting, we created an agenda for our multidisciplinary team that now convenes every month and discusses the different systemic issues we face. It doesn't cost anything. So I think a lot of this can be done through just support and through a national center of some type and online. And these things are doable even without money.
Recognizing that we really lack metrics for measuring successful outcomes, so it's hard to say what's a really effective APS program without those. But we know that there's sort of consensus about some strong programs in this country. And on, Georgia, for example, Texas are known for having strong APS systems. They cover vast rural areas. Mm-hmm. And I think we can learn from their practical hands-on experience in very rural communities and learn some lessons, but we just got to devote some resources to teasing out what those lessons are. I mean, APS works in Dallas, but it works in really isolated little spots out there in the western part of the state and elsewhere.
Sometimes it's out in those rural communities, there's less turf to deal with, fewer agencies to deal with.
Judge, I'm going to give you the last word, and we're going to take it.
All right, I was thinking in terms of train the trainer, because I get that question quite a bit, even within Illinois. Talk about what we're doing in Cook County. It's like, well, what about us, downstate? It's possible for us to take this information and just pass it along, and the online method is also good. And I know the National Center for State Court is already involved in trying to get that message down to the rural areas.
Good. All right, well, everybody join me in thanking this great panel. And thanking as you could tell, this was the largest panel, so I think could all feel it in the length of time we didn't necessarily get on Q&A, but I very much want to thank you all and tell you it's wonderful that you're here. I encourage those on the panel up here, if we have more questions, to reach out and ask them. Okay, team, so I think at 10 minutes till, we'll show another video, and then we'll start the last panel, okay? Do we have, Edwin, I'm hoping we have one more, yeah. Thank you.
This was really great.
Yeah.
It's a good point.
Do you know Paul Greenwood here in the back?